Yo, what's up, people? We is back on a late night. Probably come out early in the morning, but another day of Keep It G News. And today, we back on Ralo because it's been a mix-up. It's been a mix-up, man. You got 1090 Jake then went on record after having a conversation with Ralo and reviewing the same paperwork that I'm ready to read for y'all. And he came away with the fact that Ralo didn't tell. Now, I disagree. And I'm going to break this paperwork down. Probably like y'all never heard it broken down before, because they say 1090 Jake is the paperwork king, but I beg to differ. Straight up. And we going to get into it, man. Straight up, man, because I'm going to tell y'all exactly what Ralo tried to do and how it all went wrong. And why is it classified as snitching? Let's rock. Conflict is about a proffer that occurred at which Mr. Davis provided information to the government. And it's my belief or our position that Mr. Steele and Mr. Davis want the fact kept out of the public knowledge. That's the point of the conflict. Their argument is that the United States knew or should have known that Mr. Joshua was a target of investigation when he sat down with Mr. Joshua and Mr. Davis for that proffer June 6th. And so, I don't know how we talk about it without sort of acknowledging sort of what the facts are, for one. And then on top of that, the existence of a proffer does not necessitate a closed courtroom. So that would be blank. And I've got a couple of other preliminary things I'd like to raise with the court. But that would be my response to the first issue. The court response, Mr. Steele. Mr. Steele response, Your Honor, if blank. Those are my concerns, by the way. They are articulated correctly by the Honorable Prosecutor. As far as the proffer on June 6, 2018, Your Honor, if you do not close the courtroom, then I think we would ask the court to order that we refer to that as the date that we're all aware of in a meeting, rather than a proffer, which people will know what occurs at a proffer. And if the court would instruct the parties to do so, that would at least help Mr. Davis somewhat contain it. As far as the lawyer, if we could just refer to the lawyer for now, if you open the courtroom as maybe AJ for Attorney Joshua or something, prior counsel or something like that, that would assist a little bit. I still feel though the same that I don't know why at this point we need to open this up to the public, because I'm assuming I don't know this, Your Honor, but I assume that Mr. O'Brien is going to leave here and make a phone call. I'm not ill-willing that, and he's going to be surprised at the allegations that are coming out. And then it's a small community of prosecutors and defense lawyers, and I believe it will hurt Mr. Joshua if it comes out on June 6, 2018 that Mr. Davis gave information. I know this honorable court has been privy to that actual notes of that proffer. That's a lot of information on a lot of people that are well known in this community, and that would not bode well for Mr. Davis or his security interests at all. And I don't see the benefit at that point. The government is true. That's a critical date, June 6th, and we are prepared to present evidence that there was knowledge or knowledge of an actual conflict or knowledge of a potential conflict or possible conflict as the case law demands by the date. But I'm also going as I wrote in my pleading. I'm going to further. We were not told about any of this conflict. The real conflict, not the Mr. Joshua was on a piece of paper until 5 months later. And we have evidence that the day after the proffer, June 6, 2018, the proffer, June 7, 2018, the government's own notes, and I sent them all to the honorable court. I understand that the need of context, but the government probably understands that. But I believe we're going to prove that at least in a light most favorable to Mr. Davis and most favorable to the government, at least by June 7, 2018. The government absolutely knows there is an actual conflict or potential conflict, and they still use that passcode that Mr. Davis provided with the conflict counsel the day before to get into his phone. Tremendous amount of inculpatory evidence, crazy inculpatory evidence. They continue to do supposed plea negotiation with Mr. Davis' lawyer without my knowledge. I'm not on any of the correspondence. I'm not ready to prove that. And this goes all the way until October 5th, 2018. So we're talking about 120 days later, basically. So I don't see the need to get into the weeds of the proffer or even announce that it was a proffer. I don't think that it has anything to do with this motion, and I think that it will be very harmful to the security interests of Mr. Davis. As the court replies, let me ask you this as to the proffer. One of the allegations in your pleadings is that Mr. Davis gave the proffer blank, and I haven't seen the proffer letter, so I don't know what it contains in the proffer letter itself, but blank. But I've now reviewed blank, and I don't know if it's an ATF report of an interview or an FBI 302, but it's one of the exhibits. I tried to avoid reviewing it in the past, but I've now read it. And one of the allegations in your pleadings, in one of your paragraphs in the blank, in Mr. Davis' supposed statement was a blank where he did not disclose, based on alleged prior agreement, the source of the marijuana that's involved in blank, that's supposed to be involved in this case. So how do we get around that? That's the part of the claim that you have, which shows that Mr. Josh was conflicted and the government knew it. Mr. Steele replies, and I was going to just point that out to you because I provided that proffer yesterday to all, and I wrote on it, do not share with anyone pursuant to your honorable court, because you said to share with you the proffer with the government of both parties, but we all agree that it would not go anywhere else in the public records. And I will point to the page and the paragraph number that the court referred to, which is accurate, and it's very telling to me. And I'm not trying to argue what, is going to come out, but Mr. Davis is discussing that entire marijuana trafficking issue, all the flights taken, the pilots knowing about it, and then who's the supplier, which we know now, according to the government, is Mr. Joshua's partner, maybe Mr. Joshua himself, blank. When I say Mr. Joshua's partner, his business partner, Mr. Manu Jones, M-A-N-U Jones, and Mr. Joshua refused that. And what they really does, Your Honor, is that really a part of our agreement to prejudice. That's the combustion, blank, combustion of the engine and exploding, because now Mr. Davis is in early. We're going to lay out the timeline for the honorable court. He is cooperating against heroin, methamphetamine. He knows about shootings and the marijuana, but the government doesn't have the blank. He's not answering the questions. And we believe that blank, we're going to prove that was a fatal to his cooperation. And the government used this time to get information not only against Mr. Davis, but against Mr. Joshua. And we're dragging Mr. Joshua along and Mr. Davis in violation to his Sixth Amendment right for these next 120 days. And now, it's 2 years later, Mr. Davis can't cooperate against anybody. Everybody in the case has been revealed. In addition to that, Your Honor, you do have blank. Can I just check one thing, Your Honor? The court, of course. Page 142. Notice that the court, there's a potential conflict. It does not say anything about what we know today. It simply says that Mr. Joshua is in a partnership on a business in the state of Oregon with Mr. Jones, who is a co-defendant in the case. So I think it's admissible. The court, Mr. Buchanan. Mr. Buchanan replied, Your Honor, I guess for blank, as the court has inquired, because these dates are all over the place, and perhaps this exhibit helps with the dates, because blank, the important dates, June 6th, the proffer, July 24th, my email to Mr. Steele about Mr. Davis and the cooperation. And then here are August 24th. At this point, I have informed both Mr. Steele and piecing together when these dates and when these key factors happened, such as when Mr. Steele was notified that there was a conflict. The court replied, well, I'm going to admit blank, admit the letter. I don't know that it's so limited. I think there's some blank, assuming there's a violation at some point in time. The defense is on some sort of notice about Mr. Joshua now, I don't think that we're going to find a case like this, at least in federal court, where one of the lawyers of a jointly represented defendant becomes a target in blank. But I do believe that there are, blank, whether it's July the 24th or August the 24th. There, blank. There are blank, or sometime in between or sometime before. There are benchmarks as to where the picture are starting to become more clearer, and so I will blank. I will omit the letter. And 22 is just a part of the page 23 of the transcript from the hearing in front of me. Mr. Buchanan replied, no objection to that. The court replied, okay. So, any other evidence today? Mr. Steele. Mr. Steele, yes, sir. May I have 1 second, Your Honor? The court, of course. Mr. Steele, Your Honor. Did this honorable court wrestle with Mr. Davis, number 1? It's the DPS, the initial seizure. It just shows the very first date about $1 million of marijuana was seized on January 22nd, 2017. I don't remember it being discussed. The court, yup, Mr. Steele, blank. Mr. Davis is saying posting on an Instagram account. He's saying I've lost more than the man has gained in a lifetime. Have you ever lost $1 million at one time? That was also at the bond hearing and on page 3. It's an actual posting. The court, yeah, Mr. Steele, blank, from Mr. Davis with a picture of him, Your Honor. If you remember that date and the time, Mr. Joshua on the poll camera is at this location walking with Mr. Davis at that point. And that's why I put it in. Also, in number 9, Your Honor, of the same blank, second page of the defendant's blank, Mr. Davis too. I just wanted you to take note, if you don't mind, in the number 9, the third paragraph, blank, blank, the third sentence, the third line rather. I'm not saying his name on purpose, but he's on the flight that captured the $1 million. And so it relates, and then he gives the name of Mr. Manu Jones, which the government already had Manu's name with a phone number. So that's why I put that in. I don't believe the government has an objection. They told me. But that I just wanted to give the context. The court, okay, I'll admit too if there is no. Mr. Steele. And then, number 3, Your Honor, is in. Number 4, I don't believe that we discussed. And this is just blank again. And I blank. It's a document. January 23rd, 2018. Mr. Buchanan. Can I see that one? Mr. Steele replied, yes, sir. The court, okay. It's authorized the pen. Mr. Buchanan, yes. Mr. Steele, and Your Honor, these blank. May I speak blank? May I just speak about the document for the court for 1 second? The court replies, okay. Mr. Steele replies, in the first page, Your Honor, right in the center under the synopsis, it gives a 5707 number and a 2469 number. The court, right. Mr. Steele replies, and this is how I'm getting to the 5 phones in the next paragraph under enclosed, Your Honor. That's going to be a 5797 number. So I'm just blank when the court goes back or hears testimony in the future. I'm just trying to lay out all the numbers. And then on the same document on the 5th page, Your Honor, this is the number blank, the first paragraph under greeting, the last line in the phone number right in the center. For the number it's 6419, 6419. The court, Mr. Steele, blank, that's another number of Mr. Davis's. So I'm just trying to give the court context of the phone numbers that are targeted. The court replies, yeah, I'll admit it. Mr. Steele, Your Honor. Number 5 is blank. The court. The administrative subpoena. Mr. Steele, correct. And it say blank. It's a phone number, 6419. Mr. Buchanan, no objection. The court replied, it's submitted. Mr. Steele, Your Honor, I believe this is in, but I have it marked. This is number 5. This is going to be blank. The court, it's number 9. Mr. Steele, number 9, you're correct. Yes, Your Honor. The court replied, yes. The search warrants are in because they're part of the record. The court record. Mr. Steele, okay. The court. 7 is a similar document. It's a blank, basically a memo requesting a search warrant, which was blank. Yeah. that Judge Larkins issued. Mr. Buchanan. Okay. No objection to that, Your Honor. The court is submitted. Mr. Steele. And then 13, Your Honor, is already in. That's a search warrant by the Honorable Judge Stalines. Am I correct? The court, correct. Mr. Steele replied, already in the record. The court, that's submitted. Mr. Steele, and then, Your Honor, 15 is the June 6th. I know you have that before. Can we admit that under seal? The court, that blank, that's the blank, that's the blank. Mr. Steele, can I show the document to blank? The court, that's the 302 for Mr. Davis. Mr. Buchanan, why does that have to be under seal? I guess is my question. Mr. Steele, well, I would like it to blank. I can blank. The court, well, I'm going to leave the exhibit itself under seal right now. The blank, you know, it talks about a whole lot of other people. Mr. Buchanan, so do some of these other documents that we talked about. The court, well, all exhibits, the exhibits are not going to be public record. Mr. Buchanan, okay. So will this one be treated any differently is my question. The court, no. And I'm not until the next filing of the government, which is also under seal, entitled United States Brief in support of its motion to disqualify Mr. Joshua, filed under seal on November 2nd, 2018. That is the first filing, but I found out about it on October 5th, but I'm just blank on the record, just so the record is clear. That's the first time it's filed of all the information that we're talking about today. The court, okay, Mr. Steele. So if that being said, Your Honor, I blank unless you want more law. I believe we have made our blank. I would respectfully request this honorable court to find that we made our prima facie, showing that the government has reason to believe that there was a possible non-waivable conflict of interest with Mr. Joshua as early as blank prior to June 6, 2018. And the dates I'll give this honorable court is May 8, 2018, where you heard the testimony from Attorney Winchester. And then there's another documentation including April 18, 2018 seizure of drug ledger, which includes Mr. Joshua being paid $40,000. And there is a poll camera on the day after the first seizure of $1 million of marijuana on December 23rd, 20 blank. The seizure was on December 22nd, 2017. On December 23rd, 2017, the poll camera captured Mr. Joshua. And in the report that this honorable court, I believe, has submitted, I'm pretty sure you omitted it. Not only that Mr. Joshua is there, his social security number is listed in there, and they will give free access to all his information. And at the same time, Mr. Joshua is there. He's seen in that report walking with Mr. Davis on a poll camera, and Mr. Davis is putting on his Instagram an exculpatory blank and allegedly exculpatory statement, I believe has knowledge well prior to May 8, 2018, to ask that question of Mr. Muhammad with the blank in the presence of Mr. Winchester about Ash Joshua. That's not just a lucky question. So by the time the June 6th meeting occurs, and all the way up until October 5th, the government did not notify anyone there was a real conflict. And then that's blank. If the court finds a prima facie showing, I'd appreciate it. The court, Mr. Buchanan, well, Your Honor, it's our position that he's not made a prima facie showing that there was a conflict prior to the June 6th proffer. Mr. Winchester was asked twice were there any questions about Ash related to blank, Mr. Joshua related to drug trafficking. We said no both times. His testimony was that Mr. Joshua was discussed in this supposed affidavit. That questioning that led to the conclusion that it was not Mr. Joshua at whose office that proposed affidavit was discussed, so that shows that there was no conflict as of May 8th when that proffer took place. With respect to the picture from the poll camera, Mr. Joshua being on that picture at his client's house after Mr. Davis' associate had been arrested, that doesn't give rise to the FBI or the ATF believing that Mr. Joshua is also criminally liable for some of those blanks, those actions, and Mr. Winchester testified that point as well. Further, the note that has been discussed at length that was found after Mr. Davis' arrest that reference what we believe is drug trafficking language, It simply pays Ash $40,000. Mr. Davis had just been arrested. So those could very easily been blank, Reading that document wouldn't necessarily tip anybody off that Mr. Joshua would be a target of the investigation. And so we get to the proffer that took place on June blank, the meeting that took place on June 6th, 3 days later, according to the document that Mr. Steele entered. 5 days later, on June 11th, we know that there is a phone extraction done of Mr. Davis' phone. We also know there was a physical review of the phone that was done at the same time as the proffer. So on June 6th and on June 11th, we know that that phone had been reviewed. United States filed its motion noting the conflict, and then we later filed the brief that really fleshed out the conflict. So, Your Honor, I believe that this is a situation, as Mr. Steele has argued, that Mr. Davis has sort of been kept from moving his case along because of the conflict. His conflict arose, and it was the government that put it forth to Mr. Steele and to Mr. Joshua and raised it before the court. And further, Your Honor, we acknowledge that Mr. Joshua has a conflict and that Mr. Joshua brought Mr. Davis in for a proffer. And that's why blank acknowledged in Mr. Steele's motion that came out of that proffer. Now he wants to go a step further and say that we can't use information that came out of the consent for the phone, for which we had a search warrant as well. But the government has taken the precaution to raise this in a timely fashion, to raise this conflict to Mr. Steele and to Mr. Joshua. I think the court would blank, and I would have blank, I frankly said, if not something that we blank, we came to easily, of finding that his lawyer was not just a lawyer, had a conflict. But even of a conflict, Mr. Steele objected, and now the idea is that it was a conflict, but it wasn't a waivable blank, a non-waivable conflict. It was just an issue with him being in on the marijuana business. But I'm blank. We informed Mr. Steele prior to the hearing on the conflict of our thoughts about Mr. Joshua and his status in this case, and his status as a target of investigation. So we would argue that given these dates, that there is no evidence, Mr. Winchester testified the one proffer among the co-defendants about when that involved even more mention of Mr. Joshua. That was with respect to the affidavit. No mention of drug trafficking, and then the other mention and the other person proffer that occurred prior to June 6th. Those questions were about Mr. Jones. And Mr. Steele wants to make the leap that if we knew about Mr. Jones, we should have known about Mr. Joshua. And that is just not borne out by the facts. And so, Your Honor, we believe the evidence shows if there is no evidence that the United States operated, under the knowledge that Mr. Joshua had a conflict, and certainly I'd be remiss if I didn't say but and we absolutely pushed back on the idea that we knew about this conflict and tried to capitalize on it, or that we somehow facilitated this by intentionally not reaching out to Mr. Steele. That allegation, I push back on that as aggressively as I can, because that's not at all supported by the facts. And it's not at all sort of how my office does business. And so for those reasons, Your Honor, we argue that he's not met his burden to establish a prima facie case to show that we are operating under a conflict, and his motion to recuse the prosecution team should be denied. The court. Do you want to respond, Mr. Steele? Mr. Steele, we trust this honorable court. We will leave it in your hands. You heard the testimony. I don't agree with the characterization of Mr. Winchester's testimony. The way Mr. Buchanan it was not We're talking about Ash Joshua in the affidavit. And that's how his name was introduced. It was introduced directly in the context of crimes. Tell us about Ash Joshua's relationship with Terrell Davis. In addition to that, the government is true. I found out on or about July 24, 2018 of a potential meeting that I was not in on June 6, 2018. But to say that I could have worked out the case, no problem, with the government is not true and is borne out by the defendant's exhibit number 19 admitted today for purposes of this hearing when Mr. Buchanan writes to himself and to counsel Joshua. It was my understanding that Mr. Davis plans to cooperate and resolve this matter. If so, I don't understand why we're having another detention hearing. Please advise. I'm available if you'd like to talk today. United States filed its motion noting the conflict, and then we later filed a brief that really fleshed out the conflict. So, Your Honor, I don't believe this is a situation, as Mr. Steele has argued, that Mr. Davis has sort of been kept from moving his case along because of the conflict. His conflict arose, and it was the government that put forth to Mr. Steele and to Mr. Joshua and raised it before the court. And further, Your Honor, we acknowledge that Mr. Joshua had a conflict and that Mr. Joshua brought Mr. Davis in for a proffer. Blank. That's what we had previously agreed we wouldn't be talking about. So I think that the agents can be questioned about those events to the extent, that the government is blank, has an independent source, inevitable discovery. I know this is not a Fourth Amendment issue, but we're going to blank, dealing with that, what's in his phone. And then, I said before that this is an unusual case. I mean, you have, the Williams case where the trial lawyer is blank, is conflicted. In almost all the cases that I've read, it's the guy. It's always the guy who is representing the defendant that is under the conflict. Here we have a conflicted lawyer and obviously a non-conflicted lawyer. And the question for the blank for me again is, let's just assume for the moment that the government knew something before the date that the government chooses. October the 5th is the date that it knew that Mr. Joshua was conflicted. And then, what is the remedy? And how do we blank with the fact that on at least July 24th, Mr. Steele, you find out for the first time that Mr. Joshua took Mr. Davis to a proffer session that you didn't know anything about. And you also find out that there was an obviously plea negotiation at that point. And so, yeah, you might. 8th or the 9th of September, well, I'll flash something out to tell you. Blank, I'm going to direct that the transcript be prepared, and I'll give you enough time to get your witnesses here. Mr. Buchanan, that was my question. When Mr. Steele sent me a purported subpoena for the witness, blank, like some of those agents work in different states and participate in interviews of an individual whom we've discussed but was not a defendant in this case. We wouldn't be blank. I don't imagine we're talking about those out-of-state agents. And so I would ask the court for some guidelines on sort of blank if we're talking about the blank, by the time of the proffer, I can understand there were 3 agents there. But who? Blank. I think he knows of the 3 agents we're talking about, right, Mr. Steele? Mr. Samuels, Cunningham, Nash, Darvish, Mr. Buchanan? That's right. The only reason I ask is because he sent some letters about other agents. I'm blank. I'm not blank. Those folks out of state. The court. Well, Mr. Steele, look at your list. If you think that those other agents are necessary, then we can talk about it. But blank. But I really think it's the blank, the agents. We are involved in who can testify about the key dates surrounding the proffer and the search of the phone database, the obtaining the information about Mr. Jones and Mr. Joshua. And that sort of, formulates obviously on July the 24th, the same day that you are told why we are doing blank. You are asked why we are going forward here. If my notes are correct or my memory is correct, that's the same day of the interview with Mr. Harp, where the question about Mr. Joshua are a whole lot more pointed and directed than the questions asked by Mr. Buchanan at Mr. Muhammad's meeting. Those are blank, Those questions are a bit different. I don't know that they blank. They raise to a level, but there's a whole lot more information that's obtained about Mr. Joshua and his involvement in the case around June the 6th to the time that we get down to July 24th. There are the blank to me. Those are some of the key dates. And when, of course, we have blank, Mr. Jones is not arrested until about a month later. I think the superseding indictments is returned on the 6th of August. Mr. Buchanan, I believe that's correct. And Mr. Jones is arrested 4 days after that. The court, okay. So if I tentatively set it down for the 8th or the 9th, everybody good? Mr. Buchanan, it's fine with the government? Your Honor. Mr. Steele, yes, Your Honor. So it was very lengthy. about 30 minutes of reading. But what y'all just listened to was Ralo trying to get a deal from the federal government, and it all went left. Now, why did it go left? Because you heard the guy named by the name of Josa, or Joshi, however you pronounce that. I call it Joshua or Joshua. But he is Ralo's friend. Obviously, he gotta be. Because he was on video with Ralo coming off them planes. And what happened in that plea agreement that, well not plea agreement, but proffer that Ralo attempted to get from the government, he brought this lawyer with him. You know? And it became a conflict of interest because, come to find out, this lawyer is in some type of, he dealing in drugs, some type of way. So, when Ralo gave the police his phone, he gave his phone to the police during that hearing. So what happened was, since there was a conflict of interest and the police already had the phone, Ralo couldn't use it for his deal. So a person got arrested off of Ralo giving him that phone, a guy by the name of Manu Jones. So that's why Ralo couldn't get a deal. And that's why he said that, well, I ain't giving nobody got locked up on behalf of me. Because technically, they didn't. But in reality, they did, because Ralo gave the police, the FBI, his phone. And through going through that phone and looking at them messages, they figured out that Manu Jones is somebody that need to be arrested, because he's implicit or complicit in this drug organization, trafficking organization. But it all got scratched as far as for Ralo and the deal that he was trying to make with the government, because he had this lawyer with him and there was a conflict of interest. So basically, any information that was given to the federal government while Ralo had this lawyer couldn't be used. That's why you heard when Brian Steele was saying he can't cooperate. Y'all got all the evidence. Because Ralo gave them all the evidence. So I don't know if Ralo paid 1090 Jake to say he didn't snitch, but we just read it in wheat. Ralo told. It just didn't benefit him because of the conflict of interest. That's what happened in this whole situation. So don't let nobody on YouTube try to spin it for you any type of way. Straight up. But that's all I got for y'all. I know it was a long video. It was lengthy, but it was interesting. You know, it was interesting. And John Doe, or Get Doe, however his name is, he stood on what he stood on, and he ain't back down. Even with the internet turning against him, because you got guys like 21 Savage talking about he reached out to Brian Steele, and Brian Steele told him that Ralo didn't tell on nobody but himself. Technically, he did. He did. But he also told on Manu Jones as well. And I don't even think that's even possible for 21 Savage to do, because there's something called client confidentiality between the client and the lawyer. So Brian Steele can't even reveal that type of information to 21 Savage. So I don't know how that happened or how that was even possible, but that's Brian Steele can get in trouble for that. Straight up. You can't leak your client attorney. That's what's called client attorney privilege. You can't leak information to somebody, an outside party that don't got nothing to do with the case. That's illegal as a motherfucker. I don't even sure if 21 Savage even did that, man. He might just been part of the play to back up Ralo. And it's crazy because people in Atlanta still standing with Ralo even after the paperwork. Even after the paperwork. And I was one of the guys, if y'all watched the original video I did on Ralo, I was one of the guys that was championing that boy from the beginning. But it is what it is. The man told, he went out, said, now everything that he done for his people don't even matter no more, man, because it wasn't genuine. You wasn't standing on them same morals and principles that he was trying to instill in others. So it's not respected. And 1090 Jake, supposed to be the king of paperwork, he compromised. This is a prime example of a person that's willing to take money. I'm sure it had to have been some type of transaction, allegedly. That's the only way I can see him getting up on there and lying, because he lied. Ralo did snitch. And then the paperwork that Ralo released didn't give no information. John Doe released about 20 pages, 15 pages. And he told, and he got Manu Jones arrested. Because if you listen to that paperwork closely, Ralo and them got arrested in April. Manu Jones didn't get arrested till August. Remember, Ralo started cooperating in June. Once they gave him that phone, he got arrested. But Ralo couldn't use the information that he gave to the federal government in the phone because they obtained it when Ralo had his so-called lawyer, which was probably his friend, that could have been complicit in the whole situation as well. And it was a conflict of interest. But let me know how y'all feel about this in the comments. Like I said, it was a lengthy video. Make sure y'all subscribe to the channel. This Keep It G News. I'm always give it to y'all 100% real. You feel me? I ain't got no picks. Straight up. If he a rat, he a rat. Ralo's one of my guys. I liked him. Respected him. And I'm one of the people, I don't really even get caught up in the music. I watch the interviews and decide if this a guy I'm going to listen to or not. And he was one of the ones I chose. Now it ain't respected. Make sure y'all subscribe to the channel. Keep It G News, and I'm out.
I'm probably gonna die if I lead a clan. You got your turn and you turned your back. You turned around, ain't no turning back. I can't be the boss and no us and that. I'm bringing bow and I'm bipping with 2 times. I bought the drink and the cake, got a coupon. Make 20,000 a neck on a futon. Sitting out, cause my brother in Jumon. Why you telling people you selling fentanyl? Why you telling feds you selling shit at all? Why you telling cops if you about to get it all? I'ma tell you nothing, I'm already squeezing. You be dreaming about your dreams. I be living out my nightmares. I been missing, I been bad. The other night she was right there. I be lurking with my bros. I be crying with my mom. She be praying to the Lord that I don't turn into a monster. You be dreaming about your dreams. I be living out my nightmares. I been missing Kevin Bates.